We're here for a final pre-trial conference. I know that there's another case that we just dealt with, and that is People versus Tiffany Jacobson, in which the people have requested to consolidate one of these files with that of Miss Jacobson. In that would be file 3614. But we're going to postpone that and let's see what we're doing. Do we have any resolution to either one of the two cases? Mr.
No, Your Honor.
Thank you. All right, Mr. Ringstrom. That means that we are able to go to trial on 3614.
3614 would be the file that we filed a motion to.
3619.
So 3619 would be the one that
Right.
be stuck.
Thank you very much. Yes, sir.
Your Honor, I did file a motion this morning asking, motion to adjourn the trial date. And, bring it back
Sure.
up.
Let me see it.
Actually, I have one for each
And
of
we're
the
talking
trials.
3619.
I have one,
19.
3614 and 3619.
Okay.
I'm sure one of them would have been. not going anyways.
3614 is adjourned. We know that one.
Sure.
So I'm going to make a note. 3614 is adjourned because we have a motion to consolidate with the People versus Tiffany Jacobson, 3606. Now let's take a look here at the motion to adjourn the trial date. All right, I'm thumbing through the file looking for some information, and I've come across the prosecutor's objection to the defendant's second discovery request. Was that ever set for a hearing? That was filed there on June 23rd.
It was never set for a hearing, Your Honor.
Okay.
At the time, the objection in there informed Mr. Dick that if he had any specific objections going forward, we can go and argue this motion, but he has not said anything about
Okay.
the issue with discovery.
All right, I don't need to address anything there.
There is, I assume the court had noticed there should be a prosecutor's motion to quash its name on the defendant's witness list.
Yeah, I got that. We'll deal with that in just a second. All right. So I'm going to take a moment here as I continue to review the defendant's motion to adjourn the trial date. Transcript, we dealt with this a little while ago with the person who left and said they were going to do it, but of course failed to do it, never did it. You know whether or not Linda was supposed to assign
I don't
those
know
to somebody
who
else.
got hers. I know I got quite a few of them yesterday.
All right, we'll look into the transcript for this one.
So, Your Honor,
Yeah.
I did speak with Heather in the district court office this morning, and I guess she has been assigned.
Oh, okay, and then she has been assigned. All right,
Okay.
all right, so thank you. What, besides just getting the transcript for testimony and cross-examination, is there some other reason, any other motion that would come out of the transcript? Did you handle the probable cause, I'm sorry, the preliminary exam?
I did, Your Honor.
Okay.
Yes.
So is there something in there that you think is necessary for a motion?
So the only other thing, your scheduling order, Your Honor, says that the witness list has to be filed at least 28 days before the trial date, and only it can be amended with report. So there's potentially additional witnesses that might have been mentioned in there that I don't have their names at the present.
Okay.
So I would need that to add.
All right. Well, that I can always do a workaround and get you a recording of it and allow you to have access to that while they're still preparing the transcript. All right, so the next question here is, there's something here, you're requesting to complete DNA testing of evidence. What evidence needs to be tested for DNA?
So, Your Honor, the DNA evidence would be a urine sample.
Okay,
And
and she's got a charge here of possession.
yes.
So
among other
was there,
things.
hold on a second, Mr. Racer, why don't you tell me what the nature of the possession is?
For this file, actually, we have her on delivery of, not the honor, controls of delivery.
Okay,
manufacturing.
hold on. I thought I was looking at. Oh, that's 319. That one. I should just keep this over. Yep, okay. I was looking at the wrong one. All right. So we've got a delivery, an R&O, and contraband into the jail, and then a tampering with evidence. So where does urine come in? Is the allegation that she swallowed it and then that's why you need pee?
The allegations would consist of, I believe, I don't want to speak for Mr. Dick, but I believe where he is coming from is urine samples that were taken from other inmates in the jail that had said that she had delivered meth to her. There was a urine sample that was done. I don't think that we have any more urine samples. I'm not exactly sure which he's talking about as far as it goes, because we had a blood draw.
So what urine samples?
So they would have been the initial drug test at the jail, Your Honor.
So do you know if they kept the urine?
I'm not 100% sure at this point in time, Your Honor. I was going to ask the court.
I do not believe they kept
Yeah,
that.
Your Honor. So
So do the people intend to offer any evidence
We do
of
not.
urine tests?
No, Your Honor, we do not.
Are there blood tests from these individuals?
There was blood tests that were done, a blood draw was done at the hospital, and then they were there. We had it tested, and I'm trying to come up with a chain of custody. I thought that they destroyed it afterwards, but I'm not sure.
Hold on. Let me see if I can catch this correctly. The alleged delivery occurred allegedly in the jail.
Yes,
And some of the witnesses that the people have listed must be the other inmates.
yes, Your Honor.
And those other inmates may have tested positive for methamphetamine,
Yes,
correct?
Your Honor.
And that would be used to corroborate whether or not they did or didn't, or whatever their testimony is, whether or not they received it from the defendant allegedly.
Yes, Your Honor.
Okay, and so was there P tests done?
Originally, my understanding was there were P tests that were done, but based off of the P tests, they wanted someone to get the blood samples.
So it's the same thing as a preliminary breath test. So they then went and got a blood draw, and those blood draws allegedly report that they had methamphetamine or didn't have it in their system.
Yes,
Either
Your
one
Honor.
of the two. All
Yes,
right,
Your Honor.
so,
I can make the connection.
yeah, go ahead.
Your Honor, so the one of the allegations that kind of sparked this whole issue was that there was urine given by one of the inmates to my client to like circumvent a drug test.
Right,
The drug test that was taken came back dirty.
okay,
And the urine sample, if you were
was it the urine sample from her allegedly?
the alleged urine sample?
So someone else in the jail allegedly gave her urine that she could use to circumvent the test.
Yes, Your Honor.
And that alleged urine was tested positive anyways, right?
Yes, Your Honor.
Okay,
That's
so, all right, so you want to determine the DNA of this urine,
yes.
of that urine, not the other urine.
And the unit, the small bottle that's in I believe is labeled present People's Exhibit 4, that had a means of giving the urine to my client.
Is she charged with testing positive?
No, Your Honor. However,
Okay,
if this urine that tested positive is the same urine that was in this bottle, it would provide at least some reasonable doubt that my client had supplied.
how does it apply reasonable doubt? If
Well-
that witness, do you know who gave her the, do you know who allegedly gave her the urine?
Yes,
All right, so you can ask that person if they gave her the urine.
yes,
And do we know what have they been asked that question?
yes,
And do they admit it?
yes. However,
Okay,
they also had said that they had never tested positive, or should not have tested positive because they hadn't taken anything before receiving the methamphetamine from my client. So,
and is that person one of the ones that claims she delivered it to?
Yes, Your Honor.
Okay. All right,
and if the DNA, if we're able to obtain the original P sample and compare that DNA to what was in the little bottle, that if they match, that would also be compared against my client's DNA, which would show that the positive test was not her. So that would
but she's
demonstrate.
not charged with testing positive.
Right, so the timeline of everything suggests that the urine was provided before the fake urine or urine that was provided to circumvent the drug testing was provided before the methamphetamine was given. Now, if that urine actually tested positive, then that person likely or must have had the methamphetamine before she gave the urine sample to my client.
Oh, before what?
Before,
All right, you gotta stop talking proper. You gotta figure out your argument, because I don't think you even know your argument. So she tests positive for urine using someone else's pee, and they obviously had used methamphetamine, therefore it caused them to test positive, but they have somehow said they never tested positive.
they said that they couldn't have tested positive at the time they gave my client the urine.
Okay, but does that person now testify that she gave them methamphetamine at some time?
Yes, Your Honor. If I may
Yeah,
try and clear up the facts, what is, I believe Mr. Dick is arguing is we have a situation where one of the inmates admits that Miss White had wound up giving her urine. She admitted that she gave Miss White urine in a plastic bottle. And that's what I think Mr. Dick is talking about, is this plastic bottle. That tests did allegedly come back positive for meth, which Molly White claims.
how was it tested? In a lab or with the dipstick?
It was just tested
At
at
the
jail.
jail.
It was
All
just
right.
tested at the jail. So what Mr. Dick is saying is he wants it tested to be able to show that maybe it's Randy, the other inmates' DNA that's in that bottle that supposedly tested positive. The other inmate definitely did admit that she wound up putting the urine in the bottle for Molly White, but had indicated that she has no idea how that could have come back positive because she had not used beforehand.
Okay,
I don't know where the DNA
but
comes
she's
in.
not, but Miss White isn't charged at all with anything about the urine bottle.
No, I believe what Mr. Dick is trying to argue is that the other inmate would have been tested positive for meth before acknowledging that she was in receipt of it.
So in other words, the P tested positive for meth that she got from somebody else other than her.
Prior to that, yes.
Okay. Because she couldn't have gotten meth from any other person. And did you find out how long she's been in jail? Had she been in jail without a period of time for it to clear her system?
Well, I believe she had been in custody since sometime
They
around.
gotta, yeah, you gotta
December,
stop this
January.
believing and putting together a timeline that you can't put together and try to explain it. So let's skip back to the very first question. Is there any urine to go test?
I do not believe that there would be any urine to be able to test. I think Mr. Dick is trying to argue he wants DNA testing on the plastic bottle that was used.
Is the bottle still here?
Yes,
Okay. So we're not testing urine, we're testing for remnants of DNA inside that particular bottle. Okay,
If the urine samples are available, Your Honor, I was seeking to obtain at this time.
Okay.
And I don't know 100% that they are or not, but
or not what?
that they are still available, or if they are not still available.
He said they are. He
the
may,
bottle is, I know the bottle is, as far as the urine sample goes, Your Honor, this is the first time I've ever been requested as far as the urine samples go. I did not check. I'm pretty sure they destroyed them and got rid of them. If it does matter, I could go back and check with the jail right now as far as
you all can file, you all can set this for a hearing and you're gonna set it sometime next week.
okay.
This is a motion that has nothing to do with the transcript. Should have been brought up a long time ago. And I'm gonna tell you, you better in your motion, or if you want to redo yours, you better give me a timeline that tells me when all these people were inside the jail. In other words, all the people that allege that they got the substance from her. When did they get to jail? How long have they been sitting there? When were their last, did they have any other blood tests or urine tests in me? You gotta figure all that out. This argument's put together like, I don't know, grabbing a handful of sand and dropping it on a plate. It's guessing, and you shouldn't be guessing at this stage. So I'm not going to adjourn the trial until I have a motion or give me a reason for it. So far, I don't have necessarily a reason for it. Plus, this is not set for a hearing today. So you guys can deal with that, file it and get it on the docket. All right, so now I've got to deal with Mr. Ringstrom. We have to deal with Mr. Ringstrom's motion. Mr. Ringstrom, you were listed on a witness list in file 3619. That's the same file we were just talking about. Is that right?
I was also listed on the other file as well, Your Honor.
All right. Why is he listed as a witness?
It was because of something that happened during the preliminary exam, Your Honor.
What happened during the prelim?
I had called a witness that the people had subpoenaed to testify on our behalf. And,
Okay.
Mr. Ringstrom kind of lost his cool and told the witness that if he testifies for the defense, he will revoke his immunity. And the reason that he's on both of those is that, again, I don't have the transcript because I need that for.
Was this done on the record?
Yes.
Okay. Is there Mr. Ringstrom, before you put a witness on the stand, did he make a statement?
The witness had made a statement through a police report.
Gotcha, that's what I expect. So during the prelim, did he start to change his story or something, or not testify consistently?
As far as I know, no, he was going to testify consistently as to what his police report was.
So what is the issue with him saying if he doesn't testify according to his statement?
No, the statement that Mr. Ringstrom made was if you testify for the defense.
Okay, so how does that make him a necessary witness? Is he going to testify?
I don't know, Your Honor, if he is or isn't.
How do you not know if a witness is going to testify in a case that you're set for trial in less than 2 weeks? How do you not know? You should have talked to him.
Oh, I spoke to him.
Okay.
Like ultimately, I don't know what he is going to do at trial. I don't know if he's going to plead the fifth, which he
Well, he
decided.
can't. Did I grant him immunity?
No, he was not granted immunity, Your Honor.
Oh,
And
okay.
this was dealing with the file of the 3614. It's not even this file 3619.
And I'll get to.
What had happened is, if the court wants me. to
Yeah,
do it,
go for it.
What
He's-
happened was we had.
By the way, this happens a lot. I know defense attorneys do it. They always do it when they've been practicing for about 4 or 5 years, or somewhere less than that. They always throw the attorney on the prosecutor, and almost never, ever does it ever happen. Go ahead and explain it to me.
So we had 4 witnesses that we were prepared to go ahead and call in at the prelim. 2 of them needed use immunity to be able to testify. After the 3rd witness and 2.5 hours of a preliminary exam, prosecution decided not to call the other witness that we were going to give use immunity to.
Okay, who is that witness? Just give me a
It was
first
Mr.
name.
Ullum.
Oh,
at the
all
time.
right.
So then Mr. Dick decided he wanted to call Mr. Ullum as his witness
At the prelim.
at the prelim.
Okay,
And there was some discussion, I don't remember the specific words, obviously with the transcript or whatever, but there was some discussion as far as me saying that if he's testifying for the defense, he's not got our use immunity because we were the ones who were using it at that time.
all right.
And then after more discussion, I just agreed I would call him as a witness, but the court at that point in time had indicated that they just wanted to go forward.
All right.
I have no
Mr.
idea.
Dick, what's your version of that? Because that's a little bit different than what I heard. So tell me what happened.
So at this hearing, yes, there were 2 deputies and another witness who had been granted immunity had testified. And Mr. Ringstrom declined to call the other witness based on my prior discussion. We thought there might be.
You said he decided not to?
Pardon?
You said Mr. Ringstrom decided not to call that witness, Mr.
Yes, Your
Owen?
Honor.
All right, copy.
And I ended up calling him.
Okay,
And Mr. Ringstrom kind of blew up initially about that and said that if you testify for the defense, I'm revoking your immunity. And part of not having the transcript today is we're relying on this as the offer of proof. And it may be better to address everything with that. But I did speak with this witness, and I do not ultimately know if he's going to testify or plead the fifth or what he's going to do here. So at the
you gotta spit it out, man.
Sorry, at the
You-
same
you-
time, we
You
were.
may as well say every other word. You're not doing but I cannot follow when
That
you're
is-
talking. So just keep going. Let's see what you get.
At the time of the preliminary exam, there was again, I'm saying I believe, Your Honor, because I do not have the record, or the transcript of the record.
All
There,
right, so let's,
yes,
there was a signed order for use immunity that was in the file. And it dealt with Mr. Owen. That order says, I'm sorry, is in response to a motion for immunity, or an application for use immunity. By the way, there we go. It's in the file, but it's not even signed by the judge.
It's
Right.
not because he did not testify, so therefore the judge did not sign it. The judge was going to have him come up if I were to call him to sign the use of it.
Yeah. So hold on. it may have caught the prosecution off guard, but he didn't have immunity. And then what you run the risk of doing is pulling a witness on the stand that you might know is going to invoke the Fifth Amendment right. And you would have to then get immunity. So if he chose not to call the witness and the judge didn't give immunity, and if he's telling the witness, hey, by the way, I didn't call you, which means you don't get immunity yet. All he did was the right thing by telling the attorney, I'm sorry, the defendant, or I'm sorry, not the defendant, the witness, hey, you don't have immunity. Be careful of what you say. He did the right thing. Now, if he testifies and you all want to get him immunity, fine. But how is that even relevant? Let's do it that way. How is what he said to Mr. Owen relevant? Because you don't know if he's going to test. Are you going to call him, right?
That's the intent.
Okay, Mr. Ringstrom, are you going to call him?
I would probably want to call him if there was a trial, yes.
All right, so you're going to want an order of immunity.
I would give him the use of immunity, yes.
Okay. And then what would, so he's going to put the witness on the stand. The witness is going to say A, B, and C. Then you're going to get up and you're going to either challenge him and say, well, that's not what you told the other people or whatever. That's fine. That's prior inconsistent statements. Got that. Then you're going to challenge him to say, what? His credibility because of what he said to him?
No.
All right. How would you use this? How is it relevant under 401? How is it relevant to make a element of defense more or less probable?
Well, it would make it more or less probable that Mr. Owen was threatened or felt threatened by the statement.
How do you know if he felt threatened?
Right.
But what does that matter? How does that go against his credibility?
Well, it weighs against his credibility because it actually has an influence now of how he is testifying, or if he chooses not to testify.
If I give him an order of immunity, he can't choose not to.
Understood.
So there goes that one. So then the question is does he testify consistent with what he had to say before? John, did he testify at the prelim at all?
No.
No?
He did
All
not
right.
testify.
So, all right. How is the prosecutor a necessary witness?
Well,
He's not. You were there.
yes.
There you go. Maybe you need to be the necessary witness. Or Ms. White, but she has the right to remain silent, or the court reporter, or the judge before whom it was taking place. So the answer is you don't need Mr. Ringstrom. You have a transcript. We'll have a transcript by that date. You will strike Mr. By the way, why was Mr. Ringstrom on the other file then?
There, again, I'm saying this because I don't have the transcript, but I believe that one of the key witnesses in his other case, their mother was sitting in the courtroom here when that was said.
Okay.
And because I construed what he said as a threat rather than a warning, I believe that they would perhaps as well.
Did you talk to her?
No.
No, you don't even have the facts for the motion. He's not a necessary witness. You haven't talked to her. Boom, there goes that one. You don't know what she's going to say. You don't need the preliminary exam transcript to figure this out. This is very, very simple. You will get the transcript. I'm going to expedite it and I'll get it to you by the middle of next week. And if I have to work with a court reporter or a different court reporter to get it done, we'll get it done. Now, as for that, you're also going to set the other part for a hearing. And you're going to explain to me a lot better than anybody has done today as to how it's relevant to have a test of DNA of pee into a bottle. Sounds like at best, you're going to say that one, the person lied and didn't know how it should have tested positive, or two, that she peed into that cup before the time and date which she says she received the methamphetamine from, allegedly, Miss White. Now, if did that person, that same person get tested again after that person pointed the finger to Miss White? That's important to know.
I'm trying to understand, Your Honor, basically what it is that person wound up giving to Miss White the pee.
Yep, I got it.
That tested positive.
Yep.
Molly White had accused her of giving her dirty pee. She said, I couldn't give you dirty pee. And then that person, then after that, I believe was given the meth because.
So, right, I got it. So then did she get tested after?
She got tested after her saying that Molly White had given her the meth.
Okay, and then she tested positive
And
with
she
the blood
tested
draw.
positive for meth.
Okay, so we don't have any report that said, right, that urine was not tested at a lab.
No, that urine was not tested at a lab. That urine was tested
Got it.
through the gym.
Got it. So now what you're requesting is something else. What do you think you're requesting now?
Well, the,
One here, if I were, well, I hate to say this is tough because these motions are kind of tough because I end up telling you all what I think you're missing. And I tell you what I would do. Now that's the problem. But here's what I would hold your feet to the fire on. What are the nanogram levels? That's what you want tested. The DNA is not necessarily the information you're looking for. That might be to help tie it to the person who says, yes, that was my pee. But you're looking at nanogram levels, because if the nanogram level in that blood, and if that blood was done a week later or 2 weeks later from the whole pee fiasco, there goes that argument. So you all put this together a lot better than you did today. We'll deal with that then. As of right now, the case stands, it remains on the trial docket. All right. And so far, I'm gonna strike Mr. Ringstrom as a witness, but he is not a necessary witness. If, for instance, let's say Mr. Ringstrom had talked to a witness, Mr. Ringstrom, if he was the only one present, now he's a necessary witness. If he does it with a law enforcement officer, he's no longer necessary. You can call the law enforcement officer. So here you had a room of people. He's not a necessary witness. If she feels intimidated, that's a question you can ask her. Did you feel intimidated? But then he's going to put out a transcript of whatever was said or a recording and play the recording, and then the jury's going to make a determination if that was reasonably to feel intimidated. I'm going to tell you, often you end up putting the word intimidated in people's mouths. But because I deal with that a lot when I deal with personal protection orders. I was harassed. Well, what do you mean by harassed? And they tell me, I'm like, well, that's not the definition of harassment in the law. Anyways, you guys can set this for a motion. I'm going to go find somebody to put this thing in the transcript request line ASAP. All right. So we have nothing resolved today. This case, well, 3619 goes to trial unless we make a change next week. I'm getting tired of adjourning trials. So, all right. Thank you very much.
Your Honor, this trial was set for 2 days based off of the preliminary exam, the length of the preliminary exam and the witnesses. I think that we probably are going to need 3 days.
When is it? Is it set for trial the following week?
It's set for trial September 8th.
Tonight, yeah. All right, so we got a couple weeks. Yeah. At least 3 weeks, almost 2.5, 3 weeks. Oh, we got plenty of time.
We do.
Oh, my gosh, yes.
People are ready for trial.
All right, thank you very much. We're. All right, did you get all the way down to the bottom? Derek, boom. Oh, Miss Bloss.
I'm gonna ask for adjournment, Ms. Bloss. It's a whole damn meet with her and she's currently housed in Emmett County.
Okay, hold on. So we're going to take up this file, people in the state of Michigan versus Andrea Bloss. This is file 25-3607. Oh, wait, do we have Mr. Weiss?
You do have Mr. Weiss. He's in question. I mean, he's in treatment.
That's the guy we
He's
saw
waiting
earlier.
on him, so.
Yeah, he's in.
All right.
He's going to be enter a plea today.
The what?
Mr. Weiss is going to enter a plea today.
All right. So Miss Bloss, she is not present. Where's she at?
Emmett County,
Jail.
correct. She's on a parole hold. She won't be released except to be transported here. She was picked up yesterday and they weren't able to go out and get her today. For today.
All right, we'll adjourn that. I'm going to see if my staff can get her on a writ for Zoom next week. We're adjourned. Next file and last file this morning, people of the state of Michigan versus Derek Wise. File numbers 25-3611 FH. Appearances, please.
Robert Champion hearing on behalf of Mr. Wise.
Mr. Wise should be joining us here in a moment via Zoom. And there's Mr. Wise. All right, and we're here today for a final pretrial conference. Parties have informed me that we have a resolution. Mr. Denon.
Thank you. It's my understanding that Mr. Wise will be accepting the people's offer, which is to plead guilty to count one, larceny in a building. In exchange, count two and the habitual fourth notice will be dismissed at the time of sentencing.
Mr. Champion.
That is a correct statement of the plea agreement, Your Honor.
Mr. Wise, is that how you wish to resolve today's file?
Yeah, I can't hear you guys very good.
All right, Mr. Wise, how about there? If I speak a little bit louder, does that make it better?
Yeah, I can make it work.
All right, thank you. Mr. Wise, I'm told today you're going to enter a plea of guilty to one of these counts. Is that what you understand you're doing?
Yes, sir.
Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Mr. Wise, you are currently charged with 2 counts. Count 1 is larceny in a building. That is a felony punishable by up to 4 years and or up to $5,000. I'm told that you will plead guilty to that count. Now, there's also a 4th habitual felony offender enhancement that could, within the discretion of the court, increase that maximum punishment from up to 4 years to up to 15 years. However, if you plead guilty to count 1 and the court accepts that plea, that 4th habitual enhancement will be dismissed. You are also charged with count 2, receiving and concealing stolen property of a value of at least $200, but less than $1,000. That is a misdemeanor punishable by up to 1 year and or up to $2,000 or 3 times the value of the property, whichever is greater. Again, that count will be dismissed. So far, Mr. Weiss, is that what you understood to be the terms of your agreement?
Yes, sir.
Now, by entering a plea of guilty, if this court accepts that plea, you will not have a trial of any kind, and you would be waiving rights that you would otherwise have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose and the court and the prosecutor consented. The right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you who appear at the trial, the right to question and cross-examine those witnesses, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have its silence used against you, and the right to testify at that trial if you chose to testify. Mr. Wise, do you understand those rights?
Yes, sir.
And again, do you understand that if you plead guilty and I accept that plea, you will be waiving those rights as they apply to this case?
Yes, sir.
Additionally, any appeal as they can pursuant to the pretrial agreement and the plea and sentence would be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements to force or compel you to plead guilty?
No, sir.
Are you entering the plea of your own free choice?
Yes, sir.
Now, Mr. Champion has probably talked to you about the Michigan sentencing guidelines, probably tried to give you an estimate as to what he thinks those guidelines might be, and also give you an idea or estimate as to what he thinks the court would do at sentencing. Has anyone, including him, made any promise or suggestion to you as to exactly what the sentence would be?
No, sir.
I highlight for you that any statement made by anybody or even the scoring of the guidelines are not mandatory. It is the court alone that determines the sentence. Do you understand?
Yes, sir.
Knowing all that, do you still wish to enter the plea of guilty that we discussed earlier?
Yes, sir.
As to count one, larceny of building, how do you plead?
Guilty.
Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. Turning your attention to May 25th this year, 2025, up in Bloomfield Township here in Missaukee County. What happened, sir?
It was probably 4 or 5 in the morning, and I went into a lean-to and took a chainsaw out of there, and I was on my way to return it the next day, and I got pulled over on their road, and
All
I
right.
was caught with saw.
And so this lean-to, what it was, tell me about it. What was it connected to?
It was connected to a pole barn.
All right. So, and did it have like a roof over it with doors or walls, or tell me?
It was just a roof, and it was open on the side of it.
Okay. And did you enter that without permission?
Yes, I did.
And did you know whose lean-to or a portion of this barn to whom it belonged?
I didn't know him personally. I just sold wood to him once before.
All right. And so did you have permission from the owner to enter that building to take that chainsaw?
No, I did not.
And then and then you left that building with that chainsaw without the permission of the owner. Is that correct?
Yes, sir.
Mr. Denon, do you believe it's provided a factual basis?
Yes, sir.
Mr. Champion?
I do also, Your Honor.
Mr. Denon, do you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. Champion?
I'm aware of none.
And Mr. Denon, do you believe the court's compliance with Michigan Rule 6.302?
I do indeed.
Mr. Champion?
I believe the court has, Your Honor. Thank you.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for count one. Therefore, he is found guilty of that count. Count two and the habitual enhancement will be dismissed at the time of sentencing. Mr. Champion, is his address still the same that's in the file? You know?
It's his mailing address, but we can also get it. He's currently in treatment up north. He's in the transitional housing program.
Thank you. Mr. Wise, someone's gonna get you a packet of information. You're gonna open it, you're gonna complete it, follow the instructions, and then turn it back in.
Yes, sir.
You're gonna have an interview with an agent from the Department of Corrections, and you have the right to have Mr. Champion present during that interview. Third,
Yes, sir.
Mr. Harrison's gonna bring to you a report called a pre-sentence investigation report, and he'll go over it with you prior to coming back to sentencing. This report must be prepared anytime someone's convicted of a felony in a court in the state of Michigan. This report will describe the offense, the pretrial agreement, statements or information you make or provide while preparing this report, as well as a report on prior criminal history, your performance on bond, your performance on probation. It will include a scoring of the guidelines, which again is not mandatory, and it will make a recommendation as to the sentence. Please keep in mind that it is merely a recommendation, as it is the court alone that determines the sentence. Do you understand, Mr. Wise?
Yes, sir.
Do you have any questions, sir, about what we have done today?
No, sir.
Thank you very much. Bond hereby continues. If we need to extend the sentence to help coordinate with his treatment, of course, the court will do so.
Thank you.
Thank you. We are adjourned.
Thank you, sir.
Thank you.
You understand that Emmett is now on.
They went
Yes.
off now.
Okay, thank you.
Who
Trying
was?
to email back and forth with one of the agents to get Emmett jailed to zoom in.
Oh,
And right as they zoomed in, I heard Judge
well,
adjourn the case, so it's, yeah.
I'm gonna ask Nicole to work on getting that done to get her on the docket sometime next week.
Is that the, give me a packet and I'll get it. Yep, thank you.
Yeah.
Mr. Weiss, you're good to go.
Okay, thank you.
Yes, sir.
Thank you.